Hello everyone, this is CS Padma Sharma and welcome to Mathurya Edu. Today we are revising one of the most important topic which is frequently asked in your examination as well, that is your writ petitions. So we have 5 types of writ petition to come and give you a gist of what are the types of writ petition. We have 5 types of writ petitions, okay? We have habeas corpus, we have mandamus, we have prohibition, we have certiorari and we have quo warranto. So these are the 5 types of writ petition. You have to remember 2 article numbers. One is your article 32 and one is your article 226. Under article 32 you are approaching your Supreme Court. You are approaching a Supreme Court, and under article 226 you are approaching the High Court. When will you actually approach High Court? So first type of your writ petition is your habeas corpus. Let's take for an example, I was detained or I was confined by any authority and I was not even given the reason why I am being arrested or why I am being detained. Then in that case I will go to the judiciary and I will go directly to the Supreme Court or High Court and ask them, I am being arrested, I am being confined, I am not even given the reason why this is done. You ask that person and then tell me. So this is your writ petition of habeas corpus. Let's understand. Habeas corpus is a remedy available. Habeas corpus is your remedy available to a person who is confined without legal justification. I am not giving you any justification, any reason why are you getting arrested. Fine. Then to have a body, this word to have a body, this word has to be in your answer sheet if you're getting the question of habeas corpus or of your writ petition. Okay, this word to have a body has to be there. So first, habeas corpus means one, we are saying that if you are arrested or if you are confined without any legal justification, then you can go to Supreme Court or High Court and file your writ petition. Fine. Now this will let the court know on what grounds he has been confined and to set him free if there is no justification for his detention. So court will go ahead and ask them that why have you arrested this particular person, and if the court does not find any valid or legal reason to get you arrested, then they will release you. Then they will cancel and there will be no detention in that case. Fine. The applicant may be the prisoner, the person who is actually getting arrested. It can be the prisoner or any person who is acting on his behalf for his safeguards, like your family member or your friends. Anybody can be there who is going ahead and filing this particular writ petition. So we have revised the first writ petition, which is your habeas corpus. We are saying this is to have a body. To have a body is the keyword of this, and we are saying if you are arrested, if you are confined without any legal justification, then go ahead and file this particular writ petition. The court will go ahead and ask them that what is the reason that you are arresting or confining this person, and if there is no legal justification, then they will release you. Fine. Next we have mandamus. Fine. The language is quite difficult in terms of mandamus, but mandamus means nothing but just to command. I am telling you that you have to do it. So mandamus is like your father in the family, okay, that if he's saying that you have to do it, then you have to do it. Fine. So you are approaching the Supreme Court or your High Court under article 32 or 226, and you are telling the court to command that particular authority to do their job. Fine. The word mandamus literally means we command. Fine. It directs any person, that is, this petition is directing any person, any corporation, any inferior court, which is the lower court, or the government, requiring him or it to do a particular thing specified therein which pertains to his or its office. That is your particular job only, and you are not doing your job. Then I will go ahead to your Supreme Court or High Court, and then I will tell them that please command to them to do their duty. This is their duty. This is their work of office. This pertains to their office. Please tell them to go ahead and do this particular task. And is further in the nature of a public duty. This writ is used when the inferior tribunal has declined to exercise its jurisdiction. Let's take for an example, if any of the inferior, that the lower courts have said that I'm not even going to take this case. Randomly, I don't feel like taking this particular case, so I'm not taking this case. In that case, you can go and file writ petition of mandamus and tell the court that your inferior court, that is your lower court, are not doing their duty properly. So issue a writ petition of mandamus. Fine. Mandamus can be issued against any public authority. It commands activity, and it is going to be an activity. You do this. This is your responsibility. This is what you should be doing. Fine. It can be issued against any public authority, but law doesn't end there. Next point says mandamus does not lie against the president or the governor of a state. You cannot issue mandamus against the president or governor of state. If they are not doing their work properly, you cannot go ahead and issue a writ of mandamus against your president of the country or the governor of the state. Fine. It can be issued against any public authority, yes, but it cannot be issued against any of your president and the governor. But also, it does not lie against the private individual. Why do we have to do this? Because see, the other people we have seen earlier are the public officers, right? They have to do their duty. The government have to do their duties. The judiciaries have to do their duties, right? If they are not doing, then I'm commanding. But I'm a private individual. I'm charging for my service. If I'm not giving my service, you don't have to pay me, right? So with this intention, we are saying that this mandamus of this particular writ is not against the private individual. If that person is not doing his job, you don't pay him. That's it. Right? But you cannot force anyone to do one particular thing. That's why it is not available against the private citizens. Except where the state is in collusion with such private party in matter to contravention of any of the provision of the constitution, it is discretionary remedy and the High Court may refuse if alternative remedy except in case of infringement of fundamental rights. So if the court feels that yes, it is a very important thing that they are not working and they have to go ahead and work, in that case the court can say and solve this particular thing. But if the court feels that we have already some other alternative remedy available, then they cannot. It is the discretion. If they feel that yes, it is mandatory, it is so much required at this particular time, they can do that. If not, then they will not do that. Fine. Now, prohibition and certiorari, let's read together. Now, understand. I have filed one particular case in any of the court. Fine. There's a court, and I have filed my case in the A court. Fine. They have accepted my case. But hearing is not done yet. Fine. They have accepted my case, but hearing is not done yet. During this time, I can go ahead and file prohibition. That they have accepted, but they are not authorized to accept. So prohibit them from continuing with my case. After hearing, they gave judgment. Fine. After judgment, I realized that they were not eligible to give this judgment only. Then I am going for certiorari. Fine. Now understand the language what I am saying. If before the hearing itself, I understood that yes, by mistake, I went to this particular court and filed this complaint, but they don't have any particular jurisdiction to accept this case. Fine. Then in that case, I am going and filing writ of prohibition. After the judgment, if I understand that the order given by the judge is not fair or was not even in their jurisdiction, but they have pronounced their judgment, in that case, you are issuing a writ of certiorari. So your prohibition is your pre and your certiorari is your post. Fine. Now let's understand the language. A writ of prohibition is issued to the inferior court, preventing the later from usurping jurisdiction which is not legally vested in it. I am preventing you that this, see, listen, inferior court, A court, X court, this is not even in your jurisdiction, so please don't accept this case. So I am preventing you from doing this. Fine. Well, mandamus commands activity, prohibition commands inactivity. Mandamus says you have to do this, this is my command. But your prohibition says this is not your authority, you should not be doing this. Fine. So it commands inactivity. This is available only against judicial and quasi-judicial authority. Now understand certiorari. Fine. What does certiorari say? It is available to any person, whether any body of a person having legal authority to determine questions affecting the rights of subject and having the duty to act judicially in excess of their legal authority. Fine. If they have given judgment or order in excess of their authority, in that case we are going for certiorari. Fine. Quashing the order passed without the jurisdiction, that is your order has been passed. Quashing the order passed without the jurisdiction by the High Court or the Supreme Court is your certiorari. So this one is your pre and this one is your post. Fine. Now finally we have quo warranto, which is your last writ. The writ of quo warranto enables inquiry into the legality of the claim which a person asserts to an office or franchise or to oust him from such position if he is usurper. Forget everything. I have to be of some basic qualification if I have to be in certain position. Fine. Quo warranto just says what is your authority? Are you even qualified in this particular position? That is what we are trying to understand here. Fine. So under quo warranto, you will go ahead and ask that there is a public authority, there is a person who is sitting in a public position. Fine. Now I want to know if he is even qualified to be in this position, because when I went to him, he don't seem to understand the concern I am putting to him. Right. In that case, you are going to oust him. Oust him means remove him from such position if he is a observer. Observer means he is not a qualified person for that particular position, right? For example, if you have to be a doctor, now this is a very vague example, but if you have to be a doctor, then you have to be having certain qualification of medicine, right? So if you are some other person and you are giving your fake documents and you are entering into this particular thing, then it is not fair. You are dealing with human lives, right? So in that case, we are saying, if I get to know that you are a observer, then I'm going to quash it and remove it. Oust means remove him from that particular position. The holder of the office has to show to the court under what authority he holds the office. Why are you in this position? Because now I am having a doubt that you are not even qualified to be in this position. So now you show me that why you should be continuing in this particular position. So you will have to, if you're not an observer, you will have to show all the basic documents, your qualification, when you were appointed, all the legal ways you were being appointed. That is how it works, okay? The fundamental basis of a proceeding of quo warranto is that the public has an interest to see that an unlawful claimant does not usurp a public office. Fine. Any unlawful person is not coming and using that public office. It is a discretionary remedy again, with the court may grant or refuse. So these are your 5 types of writ petition. I tried to revise it as much in a short time as possible. So you have 5 types of writ petition and 2 articles to remember, Article 32 and Article 226. Fine. 5 types of writ petition. One, you have habeas corpus, where we are saying to have a body. Right, why I'm being arrested, tell me the reason. To have a body, tell me a reason. Then you have mandamus, which cannot be lied against a private individual or president or the governor. Mandamus is to command, please go ahead and do your work. Your authority, your lower court, please go ahead and do your work is your mandamus. Certiorari and prohibition go together. Prohibition is pre, certiorari is post, that you have exceeded your jurisdiction. In that case, you are going ahead and filing writ petition of prohibition and certiorari. Quo warranto is just what is your authority that you are being appointed here, and in that case you feel that you are an observer, that you don't have basic qualification or the way you should be appointed in this particular position, then they will remove you from that place. That's it for today. Let me know if there is anything you're willing me to